Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series detailing testing the waters when conducting an offering using Form S-1. A roadshow is regulated under Rule 433 of the Securities Act and the free writing prospectus rules. Written roadshow materials may be considered a free writing prospectus, and if so considered, must be filed with the SEC and may only be used by companies eligible to use a free writing prospectus. If the writing is simply a repetition of the information contained in the filed registration statement, it will not be considered a free writing prospectus. As you may recall from the prior LawCast, a free writing prospectus is written materials that are in addition to or outside of the content of the filed written registration statement. As such, as long as the roadshow written materials are only an exact repetition of what is filed in the written registration statement, they may be used by all issuers regardless of eligibility to rely on the free writing prospectus rules, such as most small and micro-cap issuers and companies. Oral communications in a live roadshow are exempt from the free writing prospectus requirements under Rule 433 and, as such, may be used by all companies with a filed registration statement. Such oral communications in a live roadshow may only be made after the registration statement is filed, not before. Live roadshows include a live in-person presentation to a live in-person audience, a live real-time presentation to a live audience transmitted electronically, a concurrent live presentation and real-time electronic transmittal of such presentation, a webcast or video conference that originates live and is transmitted in real time, and the slide deck or other presentation materials used during the roadshow, unless the investors are allowed to print or take copies of the information, in which case it would really be considered written materials. As a recap of what I have covered in this LawCast series, prior to the filing of a registration statement, a safe harbor exists for any company to informally test the waters if such communications are completed at least 30 days prior to the filing of a registration statement. Rule 105C of the Jobs Act allows emerging growth companies to test the waters using both oral and written communications directed strictly to qualified institutional buyers or institutional accredited investors. Rule 105C can also be used after the filing of the registration statement. There is a statutory carve-out from the definition of an offer under Section 5 of the Securities Act for research reports, and as such, research reports can be issued on companies both prior to and after the filing of a registration statement. Rule 135 allows the publication of a limited tombstone notice of a public offering prior to the filing of a registration statement, and likewise, Rule 134 allows the publication of limited information after the filing of a registration statement. Both rules require specific disclaimers and state and federal legends. A free writing prospectus can be used after the filing of a registration statement by eligible issuers. And finally, as talked about today, a live roadshow can be used to some extent by all companies engaging in an offering. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.